Good morning, good afternoon, good evening from you joining me. Thank you for your time today. And today we're going to do Shevuot Daf 23 Amud B. The Gemara rejects this. Just going on from the previous one. The Gemara suggests if his intention was to ensure that his oath did not mention the other foods, he could have just said bread made from wheat, from barley and from spelt, thereby limiting his oath to types of bread. The Gemara rejects this. But if he had said it that way, perhaps his oath could be interpreted to prohibit only bread made from a mixture of all these grains. The Gemara suggests if the specification in the Mishnah serves merely to ensure that his oath does not extend to other foods, have him say bread made from wheat, and so from barley, and so from spelt. Why do I need to repeat bread each time? Conclude from it that the point of repeating the word bread each time is to individuate each statement as a separate oath. The Mishnah teaches if he said, on my oath I will not drink, and then he drank several kinds of liquids, he is liable to bring only one offering. If he said on my oath I will not drink wine, or honey, or oil, and he drank all of them, he is liable to bring an offering for each and every one. The Gemara asks, granted, there in the case of bread, the ruling in the Mishnah is understood. As you said, the word bread before barley and the word bread before spelt are superfluous, and serve to extend his liability so that each is considered a separate oath. But here, where there is no superfluous language, what is it to say? Perhaps the oath comes to ensure that he exempts himself so that the oath does not extend to other liquids. Since this is a possibility, he should not be liable for breaking 3 separate oaths when he drank all 3 liquids. Now, Papa said we are dealing here with a situation where all 3 liquids are placed before him. Under the circumstances, if he merely wished to indicate that his oath is limited to these liquids, he could have said, on my oath I will not drink these. Since he instead specified the liquids in the oath, it was in order to indicate that each should be considered as a separate oath. The Gemara challenges, but had he said, I will not drink these, perhaps his oath would be interpreted as meaning, it is these liquids which are before me right now that I will not drink, but I will drink other wine, oil and honey. The Gemara answers, rather, if he merely wished to indicate that his oath is limited to these types of liquids, it would be a case where he said, on my oath I will not drink liquids such as these. The Gemara challenges, had he said it that way, perhaps it could be interpreted as referring to the volume of liquids. I will not drink liquids such as these, but I will drink less than this or more than this. The Gemara answers, rather, if he merely wished to indicate that his oath is limited to these types of liquids, it is a case where he said, on my oath I will not drink from these types of liquids. The Gemara challenges, but had he said it in that way, perhaps his oath would be interpreted to mean, I will not drink these types of liquids in general, but I will drink these particular liquids in front of me. The Gemara suggests, if the point of the specification of the liquids in the Mishnah was merely to ensure that his oath does not extend to other liquids, have him say, on my oath I will not drink these and liquids of their types. Since he instead specified wine, oil, and honey, will make it clear that his intention was to individuate each liquid as a separate oath. Rav Ahaz, son of Rav Ika, said, we are dealing with a case in which another is importuning him. So what's the footnote? What does that mean? If someone importuned another to eat, saying, come and drink wine, and milk, and honey, and the latter took an oath saying that he will not drink wine, and milk, and honey, he is liable for each type of liquid that he drinks. By specifying each type of liquid, he reveals his intention to treat each one as forbidden as a separate oath. This ruling is in accordance with the interpretation of Rav Ahaz, son of Rav Ika. The commentaries disagree with regard to the Rambam's opinion in a case where one takes such an oath at his own initiative. The Rambam's commentary on the Mishnah indicates that he is liable only once. Rambam Sefer Aflah Hilchos Shevuot 4:8. To him to drink, as he said to him, come drink wine and oil and honey with me. If he wanted him to desist, he should have said, on my oath I will not drink with you. Under these circumstances, why don't you specify wine and oil and honey? Specification of the liquids serves to include his intention to render himself liable for each and every one. We learn in a Mishnah elsewhere in 36b, with regard to an oath concerning a deposit, if one says to his bailey, give me my wheat, barley, and spelt that are in your possession, and the bailey lies and says, on my oath nothing of yours is in my possession. If one denies that he owes another money, takes a false oath to support his claim, and later admits his guilt, he is liable to bring a guilt offering. He is required to return the money, adding an additional 1/5 of the sum, and only then may he bring the offering to atone for his sin. He is liable to bring only one guilt offering. But if the bailey says, on my oath, I do not have in my possession any wheat, barley, or spelt that belong to you, he is liable to bring a separate offering for each and every one. Rabbi Yochanan said with regard to the Mishnah, that he is liable even if the value of all these species combined to an amount to as little as one putta. Ravaha and Ravina disagree about with regard to this. One said, when the bailey says, on my oath, I do not have in my possession any wheat, barley, or spelt that belong to you, he is liable to bring guilt offering only for violating specific oaths for individual types of grain, and he is not liable for violating a general oath. Let's explain that. According to Rashi, this opinion understands the expression, on my oath, I do not have in my possession any wheat, barley, or spelt that belong to you, to consist of only 3 oaths, one for each type of grain. Consequently, if he did in fact have one putta of each type in his possession, he is liable to make 3 offerings for taking a false oath on a deposit. Furthermore, since they are considered distinct oaths, small quantities of each type of grain do not combine to equal one putta, for which one would be liable. Accordingly, Rabbi Yochanan's statement that they combine to form one putta render one liable for taking a false oath on a deposit is not referring to the clause of the Mishnah at all, but to the first clause, which discusses one taking a general oath that he has nothing in his possession that belongs to the claimant. The Midrash understands that Rabbi Yochanan's statement refers to the latter clause, and that where one specifies each type of grain, the phrase, on my oath I do not have in my possession, is sufficient to render him liable to bring one offering even when the grains are worth one putta, only one combined. According to the Midrash, the dispute between the Amoraim is only with regard to whether the statement, on my oath I do not have in my possession, renders one liable as an independent oath besides the oath for each type of grain, or it does not. That he does not have anything in his possession. Consequently, Rabbi Yochanan's statement that the different types of grains can be combined to amount to one putta is referring only to the oath in the first clause of the Mishnah, where he did not specify the grains. And one said he is also liable for violating a general oath, and in the latter clause of the Mishnah he is liable for violating 4 oaths, one general oath, and he does not have anything in his possession, and the 3 specific oaths, one for each type of grain. Consequently, Rabbi Yochanan's statement applies also to where he specifies the grains, and he is liable to bring one offering even when all 3 species combine to amount only to one putta. The Gemara asks, here in the case of one who takes an oath that he will not eat wheat bread, barley bread, or spelt bread, what? Hachamai. Here what? Rashi understands the question as to whether the dispute between Ravina and Rav Aha applies also to one who breaks an oath on an utterance. In other words, when one takes an oath not to eat wheat bread, barley bread, or spelt bread, and then eats an olive bulk of each, is he liable to bring 4 offerings or only 3? Some early commentaries have a different version of the text that adds, does he place himself under obligation with regard to less than a standard measure? In other words, the Gemara asks, if a person entertains the possibility that he will eat less than a measure of each and therefore takes a general oath, combining all the types. The Midrash, Tosfot, the Rambam explain that the Gemara's question is not whether there is also a general oath in the case of an oath or on an utterance. That is impossible, since once the general oath was in place, the more specified oath would not take effect, as an oath does not take effect when there already is an oath in its place. Rather, Gemara's question is whether, in the case of a composite oath on utterance, like an oath not to eat wheat bread, barley bread, or spelt bread, it is the intention of the oath taker to prohibit only eating all of them together, or to render himself prohibited from eating any of one of them. If it is the former, he is liable only when he eats from each, with the total amounting to at least an olive bulk. If it is the latter, then he is liable only if he eats an olive bulk of one. And that's from the Ritva. What is that? What is halacha? Is there a dispute as to whether he is considered to have taken a general oath alongside the specific oaths? Rava said, how can this case be compared? There, in the case of an oath of a deposit, he is liable for a general oath the general oath and for the specific oath. Since the Bailey takes an oath denying that he is in possession of a deposit, and then takes another oath to the same effect, he is liable for taking two false oaths on a deposit. Here, with regard to an oath to prohibit oneself from eating, if it enters your mind that he is bound by a general oath, why would he be liable for the specific oaths? He is already under an oath due to the general oath, and an oath cannot take effect when the matter it prohibits is already forbidden by another oath. The Mishnah teaches that if one said, "On my oath I will not eat," and he ate foods that are inedible, he is exempt. If he said, "On my oath I will not eat," and he ate the meat of unslaughtered carcasses, he is liable. The Gemara asks, the Mishnah itself is difficult. You said that if one said, "On my oath I will not eat," and he ate foods that are inedible or drank liquids that are not potable, he is exempt. And then the Mishnah teaches that if one says, "On my oath I will not eat," and then he ate the meat of unslaughtered carcasses or treifot, pregnant creatures or creeping animals, he is liable. What is different about the first clause, that he is exempt, and what is different about the last clause, that he is liable? Non-kosher animals are also unfit to be eaten. The Gemara answers, this is not difficult. The first clause is where he took an oath not to eat without specifying what included in it. Presumably his oath did not include items that are not ordinarily eaten. And the last clause in the case where he specifies what he will not eat, e.g. unslaughtered carcasses, and nevertheless eats, then the Gemara asks, you may raise a difficulty with regard to the case where he specified that he will not eat non-kosher items. Why? He on the oath from Mount Sinai, and the oath does not take effect to prohibit that which is already forbidden. Rav and Shmuel and Rabbi Yochanan all say that this is a case where he incorporates into the oath that he will not eat some permitted items. According to the Rambam, one who takes an oath not to eat and then eats food that is forbidden by Torah law is exempt from liability for an oath on an utterance. But if he takes an oath not to eat dates and non-kosher meat, and he eats an olive book of non-kosher meat, he is liable for breaking his oath on an utterance. Since he incorporated permitted items into his oath, it also takes effect with regard to the already forbidden items. This rule is in accordance with the Mishnah as it is interpreted by the Gemara. The Torah rules that even when one takes an unspecified oath not to eat, it takes effect on items that are already forbidden. Since the unspecified oath implicitly incorporates permitted items, this is in accordance with the interpretation of the Rosh and Rashi on 24a, that the Gemara ultimately rejects the need to interpret the Mishnah as referring to a case where he incorporates into his oath both non-kosher food and permitted items. Accordingly, provided he does not limit the oath only to items that are already forbidden, the oath takes effect. Romans Sefer Shevuot 5:5-10, Shevuot Daf 238:6. Along with the statement concerning forbidden items, since the oath takes effect with regards to permitted items, it also extends also to the forbidden ones. And Reish Lakish says, you find that one is liable for eating non-kosher food as a result of an oath only if it is an oath where he specifies that it includes a half measure. One who takes an oath not to eat any amount of non-kosher meat and transgresses and eats less than an olive book is liable for violating his oath, since he is not under oath from Mount Sinai with regard to less than the legal measure. This ruling is in accordance with the opinion of Reish Lakish. Although Rabbi Yochanan holds that consuming less than the legal measure is prohibited by Torah law, he agrees that one is not considered to be under oath from Mount Sinai for it. Rambam Sefer Shevuot 5:7 and Tzidkei from Mishnah Shevuot Daf 238:4. And in accordance with the opinion of the rabbis, that one is not liable for eating a half measure unless it is specified in the oath. Since eating a half measure not prohibited by Torah law, the oath takes effect. Alternatively, you find that one is liable if he took an oath without specifying that the oath prohibits less than the usual measure. And according to the opinion of Rabbi Akiva, who says that a person renders himself prohibited from eating any amount by taking an oath not to eat. The Gemara asks, granted, it is understood why Rabbi Yochanan did not say like Reish Lakish, and he interprets the Mishnah so that it is according to the opinion of everyone. But what is the reason Reish Lakish does not say like the opinion of Rabbi Yochanan? The Gemara answers, Reish Lakish could say to you, when we say that a more inclusive prohibition which adds additional aspects to the prohibition for the same individual can take effect where there is already prohibition in place. Thank you for listening and wish you a very good day. All the best. Bye.